Legal expert Benedict Phiri joins us for more on the story. Benedict, appreciate your time. So much to unpack, many questions to ask. But let's start off with an elaboration on the process by which individuals are selected and added to the ANC's cadre database. How transparent is this process, and what criteria have we seen is used for inclusion in the process?
I think if we just look at the DA's court case that they'll be filing leave to appeal in, that was not upheld by the Gauteng Department. I think there's, the Gauteng High Court. There's quite a detailed explanation of the fact that, this cadre deployment committee and its workings are done behind closed doors, and it's not transparent to ordinary South Africans, notwithstanding the fact that the people that are then appointed into important positions in state-owned enterprises and various other government departments are actually, in a public service perspective, and and in that context deal with matters that impact the public, including what the DA says impacts their constitutional rights. So we know that that is not transparent. What has now happened with these cadre deployment records that were ordered to be made available by the ANC to the DA by the Constitutional Court is that they've been heavily redacted in instances, and in some instances there's just no records for periods without any explanation from the ANC. I think that adds to the suggestion that this is completely not transparent, and certainly in this particular instance there is no reason why this should not be transparent when there actually is a court order that these records should be made available by the ANC to the DA.
Well, the DA is John Sternhuisen, speaking to some of those documents that have been redacted, speaks to going back to the courts of law and pushing for a contempt of court on the ANC, and particularly its Secretary General. Your thoughts on that?
I think it's actually a good application because, the court order was quite clear on what needs to be provided, and that was all records, including, WhatsApp messages. So we're not only talking minutes, we're talking emails and a host of other types of communications, which were meant to be provided for the relevant period that was requested. And I think it's important to note that the ANC in those legal proceedings didn't really challenge the reasons why those records were required in protection or exercise of a right, as the DA had actually put it, and Mr. Schreiber. So, the Protection of Access to Information Act would usually allow a person to say, I can't make records available because they relate to, maybe identifying an individual in a manner that shouldn't be identified, or they show some information that cannot be shown, or a specific class of information under that act that you have to request third party to give consent to. So they didn't make, the ANC did not avail themselves of all those categories and defenses that were available under the Promotion of Access to Information Act. And now we obviously down the line where we have a constitutional court order that says everything must be made available. So to the extent that there are any redactions, those are certainly not in keeping with the spirit of the court order, and certainly I think there's a very good argument to be made that the court order has not been complied with, and we know that the ANC is aware of the court order, so unless there's any other reasonable explanation that they can bring to a court, it certainly seems that the prospects of success of that contempt application are very good.
It might be a little bit puzzling because there have been many conversations about the ANC's lack of strategy in many aspects, particularly when you look at the electional engagement of the voters in various issues that have bedeviled the ANC. And this is one of those situations where they saw this coming on the horizon. The DA didn't just suddenly pitch up and say, this is what we're looking for. They've been talking about it for some time. Should the ANC, in your opinion, done a little bit more legally instead of gotten legal advice within the confines of the ANC to deal with this matter? Because from what you're suggesting, there's a defence of sort that could have been proffered much earlier on.
Yeah, I mean, the court proceedings themselves have been ongoing for, I think, at least 3 years at this point in time. And I know, at least from what the DA is saying, that some records were actually destroyed after the court proceedings had commenced, and even after the Promotion of Access to Information Act request was made to the ANC, which would be illegal. So I think there are possibly lapses of judgment and maybe decisions that could have been made better by the ANC in this context. I'm not sure whether we can put that down to the legal advice it had received, because we don't know what the legal advice it received was and whether it decided to accept or not accept that legal advice and what the reasons for that may have been. But certainly it's quite clear when you look at this in hindsight that there are errors in judgment that have been made by the ANC, and that this matter could have been handled a lot better to perhaps prevent this particular outcome. And I think the one that would be most concerning is the fact that the destruction of those records once a Promotion of Access to Information Act request was made would attract a criminal sanction.
Do we have any indication, do we have sufficient information to be able to extrapolate what sort of information the ANC would have deleted or destroyed? We obviously may not be able to pinpoint the very sentence that was destroyed, but do we have an idea of what sort of information or the nature of information that potentially could have been destroyed?
Well, personally, I don't really know. I haven't seen those records firsthand, but from what I'm reading, from what the DA is saying and reporting, it certainly looks like there's a big chunk of information missing in respect of the period where the current president, Cyril Ramaphosa, was the chairperson of that cadre deployment committee. So, I mean, I think that's worrying in and of itself. And certainly the records that have been furnished, I certainly haven't been able to work out without the DA what that information relates to.
So are there, Benedict, any legal or constitutional challenges to the ANC's cadre deployment policy, particularly regarding the impartiality and independence of government institutions?
Well, we know that there's this leave to appeal that the DA is filing against the decision of the Gauteng High Court, which dismissed its application to declare the cadre deployment policy unconstitutional. I think the Gauteng High Court, made the right decision in that particular instance, because the manner in which the DA's case was pleaded or presented certainly did not indicate that it had any grounds to actually, request the relief that it was requesting from the court. But we'll first see whether leave to appeal will be granted and what an appeal court would do in that particular instance. But certainly we'd expect that, to the extent that leave to appeal is not successfully granted on behalf of the DA, that matter would make its way as far as possible through the courts up to possibly the Constitutional Court.
And how do other political parties and civil society organizations view the practice of cadre deployment? Have there been any efforts prior to challenge or reform this policy at the very least?
Well, I'm not aware of, efforts to change this. And it is a practice that is, widely practiced throughout the world. I think, the Organization for Economic Development, the International OECD, recognizes that cadre deployment is, a practice or a policy that's adopted in many countries for parties that are in government to have a way of ensuring that people in government can actually implement those parties' policies. So in and of itself, it's not a policy that is an affront to how countries work or democracy, but certainly the argument is that in the way that it is being practiced in South Africa, it gives effect to skewed outcomes which tend to, facilitate corruption, etc. I think the problem is what is happening locally in South Africa as opposed to the policy in itself as a concept.
Benedict Phiri, always great speaking to you. Appreciate your views. Legal expert Benedict Phiri.